Right. So it's setting up your meeting for YouTube Live. Okay. So the first, I mean, today we are talking about arbitration and creative industries. So this is Crefovi's live webinar. And so how to actually make the most of ADR, which stands for Alternative Dispute Resolution. Indeed, in arbitration, for the creative industries, the arbitration and mediation, which are the two most prominent ADR, Alternative Dispute Resolution means and tools, are very important. Why? Because as you probably had gathered by the picture I set out on our latest Crefovi's newsletter, everything is supposed to be confidential when a dispute is being resolved through mediation or arbitration. So unlike the process in courts, in civil courts, which by default is public, so anyone stepping into the court's office can actually, court building can actually attend a court hearing. Mediation and arbitration are shred under secrecy and confidentiality, which is great for creative industries, in particular the entertainment sector, the film, the music industry, because reputation is so important in those sectors that any story, any dispute that might tarnish such reputation needs to be kept under wraps and remain confidential. So the fact that arbitration and mediation are becoming more and more to the front for the creative industries and becoming more employable tools, so to speak, to resolve disputes in the creative sectors is very important. And I wanted to discuss that with you today. First point is, what are the latest advances and trends in the ADR community and institutions to cater to the needs of the creative industries? Well, an interesting aspect of the development of ADR, so mediation and arbitration, is that more and more alternative dispute resolution institutions and practices have specialty panels of neutrals which specialize in the creative industries. So what are alternative dispute resolution institutions? Well, basically, for the last, I'd say, 50, 60 years, quite a few organizations have either set up as a standalone ADR institutions, or have created a department in this body, which basically manages mediations and arbitrations. So let's take some examples. The World Intellectual Property Office has as its first mission, which, if I understand correctly, has been set up by, there's a relationship with UNESCO. I think so. I think it's, and the ONU, the ONU, UNO, I think you were saying in English, Organisation des Nations Unies, so United Nations Organization, has set up the WIPO, the World Intellectual Property Office, which is based in Geneva in Switzerland. And so one of the main functions of WIPO is actually to extend trademarks and other intellectual property rights in various countries. Okay, so you can actually use the WIPO process through the Madrid Protocol and Convention to extend your French trademark in all the 27 member states of the European Union, plus you could also do the UK, etc., and all other countries and member states which are party to the Madrid Protocol. So this is one of the main functions of WIPO. However, WIPO has also set up two arbitration bodies, one relating to the film and media sector, and another one relating to the art sector. And actually, I'm registered as a neutral, as an arbitrator and as a mediator for both WIPO panels. One for film and movies and the media, and the other one for artifacts and art and cultural affairs. And there are also, as I was saying, some standalone ADR institutions, such as AAA, the American Association of Arbitration, which has an international body called ICDR. And this, for example, is a standalone mediation and arbitration institution. So in the last 60, I'd say 70 years, there's been a big development of ADR institutions, because this way of resolving disputes through secrecy, through confidentiality, and also through private means, because the public courts are not involved, has become more and more popular. And what is great is that these ADR institutions are setting up more and more panels of neutrals. So a neutral is a person who has a lot of expertise in mediation and arbitration, and therefore is going to be taking the place of, in an arbitration, of a judge, either as a sole judge or sole arbitrator, or in a tribunal of three arbitrators. So that's called an arbitration tribunal. So neutrals also have expertise, in addition to the alternative dispute resolution expertise, in how to manage an arbitration, how to conduct a mediation. They also have sometimes some expertise in particular industrial sectors. And in the last, let's say, 5 years, perhaps 10 years, a lot of ADR institutions have been looking for this kind of neutral who is able to not only be an expert in mediation and arbitration, but also be an expert in the film and TV sector, in the music sector, in the art sector, in the technology sector, etc., etc. And so this is one of the basically latest advances and trends in the ADR community and institutions, which is that more and more panels of specialized neutrals are being set up in those ADR institutions. So let's just mention a few examples. Well, at the end of 2019, beginning of 2020, the Court of Arbitration for Art, CAFA, was set up in the Netherlands as a specialized arbitration and mediation tribunal exclusively dedicated to resolving art law disputes. So, for example, this CAFA is in direct competition with the WIPO's art panel that I just mentioned before, for example. So now, when you have an art dispute that you want to resolve out of court, you have an option. Either you go to WIPO at the art panel, or you actually could go to CAFA. And I am actually registered as an arbitrator and mediator on CAFA's panel of neutrals, as well as actually on WIPO's art and media and film TV panels. And recently as well, the Independent Film and Television Alliance, which is called IFTA, which is based in Los Angeles in the US, has decided to devolve the management of its long-standing panel of entertainment law-focused arbitrators to AAA ICDR, which is the American-based ADR center that I mentioned before. And this is because, as explained by Susan Cleary, the General Counsel of IFTA, IFTA's management and legal team want to focus, on basically supporting their members who are independent film and TV production companies, and therefore they wanted to outsource the management of the panel of entertainment-focused neutrals to ICDR AAA, and I therefore, as a member of the IFTA neutral panel, I was inducted into the AAA ICDR entertainment panel in February 2022 during a mandatory case management training conducting on Zoom, along with most other arbitrators from the IFTA panel. So these are two examples of specialized and focused panels of neutrals who have an expertise in a particular creative field, which recently have been set up. But it's not all. There are also, for example, the Silicon Valley Arbitration and Mediation Center, which, while not being an ADR institution in itself, he's publishing a list of basically technology experts who are potential neutrals for either mediations or arbitrations involving technology companies. So this is called the Tech List, and it's published each year by the Silicon Valley Arbitration and Mediation Center, SVAMC, which is based in North California, close to San Francisco, I think, to the Silicon Valley, obviously. So these are two of the latest advances and trends in the ADR community to cater to the needs of creative industries. So what are the best alternative dispute resolution tools and strategies creators can use in order to make the most of the latest advances in arbitration and mediation of disputes? This was the second point that we wanted to touch on today. Well, obviously, it's really important if you want to be able to resolve any dispute by way of a mediation or arbitration. It's important in your contract, in your commercial agreement that you are going to sign with your counterparty, that you include a clause in relation to, jurisdiction. You include a clause which sets out that actually, in case of a dispute, this would be resolved through the exclusive jurisdiction of this particular ADR institution. So you could say this, in case of dispute, the parties would first have to attend a mediation organized by AAA ICDR by selecting one of the neutrals listed on the tech panel of ICDR, and should such mediation fail, then the parties will select a tribunal of 3 arbitrators from the ICDR AAA technology panel in order to resolve the dispute by way of arbitration. And then you also need to mention in this clause the law which is going to govern the arbitration, and also the forum in which particular geographical place this arbitration is going to take place. And so what is quite interesting, actually, just to rebound on this last point, is that despite the fact that you need to have a forum, be it New York or London or Los Angeles or Paris, to your arbitration, nowadays, one of the most important ADR tool that is being used, especially in the aftermath of COVID, where people travel less, is that audiovisual and conference tools are being used a lot. So Zoom, on which I am actually registering this presentation, is being used enormously, so that the parties can actually have the arbitral hearings with the arbitral tribunal or with the sole arbitrator online in an efficient way, which is cost saving. It's also easier when you have parties who are on different continents, so the US, Asia, etc. It's easier to actually organize such a Zoom Zoom-based court hearing. And also, what is great with this video conference tools is that you can actually record the court hearing, the arbitral hearing, which means that this saves money, because then you don't need to have a secretary who is taking notes and taking transcripts of everything that is being said by the parties and the arbitral tribunal during the hearing, because you can record everything through Zoom and then distribute it to everyone involved in the matter. So yeah, so these are great new ADR tools and strategies that can be used by creative entrepreneurs to make sure that their affairs are managed, in a commercially tight agreement. But also, if a dispute arises, then it is possible to resolve this dispute efficiently in a confidential manner, and also in a way that the arbitrators are going to take a fair and impartial approach to the dispute. Indeed, quite a lot of parties in the creative industries, especially in the last few years, where the states have been far too prominent, and imposing a lot of restrictions on the life of individuals at large. A lot of parties and creatives are concerned that public courts are not independent and also lack impartiality. Well, that is also a great way to go around this if you have the ability to select your own arbitrator with the counterparty with whom you have this conflict, this dispute. Then it's reassuring for the parties to know that in arbitration they can actually select their own arbitrators to decide on the fate of your dispute and conflict. Same goes for a mediation. The parties select and pick and choose their own mediator. So of course that means that the mediators and arbitrators need to disclose any potential conflict of interest that they may have at the very beginning, when they are informed that they have been chosen for the arbitration or mediation. But this ability to actually select your own, so to speak, judge is reassuring, comforting to the parties. And let me see whether there are any other tools that worth mentioning. Well, yeah, in the back of the 2019 COVID crisis, a lot of public courts as well, in addition to having this sometimes lack of impartiality, they also have an enormous backlogs of cases that they have been unable to deal with and to manage during the last 2 years. So there's a very big backlog, which means that the matters stay on the docket of these public courts forever. So this is also why there has been a boost in arbitration in the last few years, because parties want to have a quick and efficient and swift resolution to their disputes, and they also want to be able to have these virtual hearings, and electronic case management methods, and that sadly is not something that the public courts have done at all. They refuse to change. They refuse to do video hearings. except in rare criminal cases, but otherwise you have to go to court. What do you do if you're on lockdown in your own country and you can't move? It's been very difficult, and yet sadly the public courts have not changed, and instead there's this massive backlog which has cropped up on their docket. So that's why also the creative industries are using either mediation and or arbitration way more than before. So there's another ADR institution which has a funny example actually about how celebrities who are legal savvy are using arbitration can make the most of ADR. So Chris Polo is the CEO of the Los Angeles-based Judicial Arbitration and Mediation Service, which is called JAMS, which is one of the top arbitration bodies in the world, in particular for entertainment matters and commercial matters, bragged during an interview that even the Kardashian sisters are using JAMS services to resolve a commercial disputes. So if you refer to my article called Arbitration Creative Industries, What's New, that I emailed you about a month ago, you will be able to see that indeed the Kardashian sisters have obtained an arbitral award against one of a licensees. So they are the licensors, and one of a licensees who did not comply with the terms of a license agreement, where they were able to use the Kardashian names. They didn't deliver on paying the royalties due to the three Kardashian sisters. And so this arbitral award handed down by JAMS was in favor of the three Kardashians, and it's been contested in court afterwards by this licensee unsuccessfully, as it was revealed a few weeks ago, because the court actually upheld the arbitral agreement. So the Kardashians won all the way, and now they're just going to wait to get these royalties paid, I guess. So so in terms of the best ADR tools and strategies creators can use, I think I've basically explained that that in the 21st century, this is the most technology savvy, efficient, confidential way to resolve disputes. So one thing that is important as well is to mention that what about the enforcement of an arbitral award? As I just mentioned, in the Kardashian case, the counterparty tried to challenge the enforcement of such JAMS arbitral award. Well, the New York Convention actually rules the enforcement of arbitral award in the various member states which are party to the New York Convention, and it's usually is a process which is very straightforward, as you need to obtain basically a confirmation from the public court that in the country in which you want to actually have this arbitral award enforced, you just have to apply to get a confirmation by the court of this particular country, the relevant court of this particular country, that the arbitral award now needs to be enforced in this country. And this usually is a very straightforward process, because a lot of courts, specialized courts such as the Paris Court of Appeal, or for example, they just 99% of the times do indeed confirm that the arbitral award is enforceable, in this case in France, or it could be the same for the UK. So So what is great is that thanks to the steady and long application of this New York Convention on the enforcement of of arbitral awards, it is possible to enforce arbitral awards in the vast majority of the times in the member states which are a signatory to the New York Convention. So of course, the US is a signatory, the UK is a signatory, France is a signatory, the EU, representing the 27 member states of the EU, is also a signatory. So, and actually on this note, the enforcement, the ability to use the New York Convention to enforce arbitral award has become critical since Brexit has removed the United Kingdom as a member state of the EU on the 1st of January 2021, because the UK is a member state to the New York Convention, and therefore nothing has changed since Brexit in relation to the enforcement of arbitral awards in the UK, while the enforcement of civil and commercial judgments, so judgments handed down by public courts, so this enforcement of civil and commercial judgments in the UK after Brexit is very tricky, because there's a legal void, there is legal no man's land, and therefore nobody knows at the moment exactly how to ensure that a civil or commercial judgment that you obtain, say, from France or Italy or Germany, any one of the 27 member states of the EU, is going to be enforced in the UK and vice versa. So that's why at the moment in our law firm, we do advise our clients who have a cross-border relationship between, say, the UK and one of the 27 member states of the EU. We strongly incentivize them to actually put in the jurisdiction clause that the a particular, ADR institution is going to be competent to resolve any dispute, as opposed to, for example, the courts of England and Wales. So. This is not something you want to have in a cross-border commercial contract nowadays. You do want to have an arbitration clause instead, when one of the party is based in the UK and another party is based in one of the 27 member states of the EU. Otherwise, if there is a dispute, it's going to be very, very difficult to enforce the decision. So that touches on the third point, which is what is the future of arbitration and mediation in the creative industries post-Brexit. I guess that it's bright. This future is bright indeed, because I can only see that there will be more and more of a gap between the public courts, which are refusing to adapt to the reality of doing business in the 21st century, who still want everyone to be in court in person, and refusing to do, as I said, these video court hearings or exchange with the parties through electronic means or electronic platforms, which means that you always have to check your letterbox, physical location. If you don't do that, then sometimes even the court clerks will refuse to send you these papers by email. So it's very tricky, and lots of creative companies and entrepreneurs are losing patience with this kind of attitude, which really has no justification, especially after COVID. I mean, we've seen how important electronic communication can be to basically make our working lives much more efficient. And so this is where, arbitration and mediation institutions are so important, because at the end of the day, they are aware that they provide a service to creative stakeholders, and therefore they want to make sure that they are attuned to their needs and listening to their needs and requirements, and request for cutting costs and improving efficiency. And this is definitely where most ADR institutions are heading towards. They're really trying to, for example, the International Court of Chamber of Commerce which head office is in Paris, but they're also quite strong in London, the ICC. It's one of the most prestigious arbitration bodies in the world, the ICC. And recently, I think around 1 or 2 years ago, they published a report on how to make the most, of electronic communication and means to facilitate the process of case management of an arbitration, and also doing those arbitration hearings online. And on the back of that, also, how do you protect data from your counterparties, from your witnesses, from your experts, etc.? How do you make sure that you protect data if everything is managed online? So it's great because they're creating this, code of conduct and data privacy policies to make sure that when these arbitrations are dealt with online, they are done on a proprietary platform, online platform, which is built in a way that there are many firewalls, so that trolls or hackers cannot get into the system to store the data, and so that there wouldn't be no data leaks. So a lot of information is, a lot of thought is put into this enhancement process and development process by these ADR institutions as a whole, to provide a better, more efficient and cost-efficient service, in particular to the creative industries. And I think this is great, because this is so different from the approach taken by public courts, who don't give a toss at all about providing an efficient and cost-efficient and quick and service to stakeholders, to in particular the creative industries. So I think the future indeed is very bright, and for arbitration mediation in the creative industries. And especially, as I said, in this post-Brexit era, it will become more and more relevant for cross-border disputes between UK companies, UK creators, and the counterparties in the European Union. And I just wanted also to add a point about something that I'm doing now. So 2 points actually. The first point is that during the year, every year, there are now some arbitration weeks, which are organized by several cities in the world, which are prominent in the arbitration space. So in March, for example, the Paris Arbitration Week took place in Paris, in physical spaces in Paris, but also on various virtual platforms. I didn't really have the time to attend that one, but one that I attended that I really enjoyed, because it was so well organized, was the California Arbitration Week, which during a period of 3 or 4 days, on a really sturdy and efficient platform, online platform, provided a lot of webinar for participants and attendees from around the world to log in and for free, and to attend all these very insightful panels and webinars about the latest updates on arbitration points and mediation points, etc. So, for example, the California Arbitration Week provided a great presentation, which I watched several times in replay afterwards, on the latest updates in the entertainment sector, in particular the film industry, in the ADR, alternative dispute resolution space. That was really great. At the same time, JAMS, which is also based in Los Angeles, as I mentioned before, had another panel during this California Arbitration Week about the same topic. So that was great. And also, so the Paris Arbitration Week happened a few weeks later, in April 2022, and through a blog which is called Walter Kluwer's blog on arbitration, I read and I learned that during the Paris Arbitration Week, there were 2 panels, 2 presentations, 2 webinars on the sports field, and arbitration and mediation. So just to let you know and to give you the heads up, I'm currently doing some research and writing an article about esports and arbitration and dispute resolution, and esports gaming, arbitration and dispute resolution. And as I said, it's really great to know that even for super specialized sectors like sports and competition events, there are some dedicated ADR institutions such as CAS, la Cour arbitrale du sport, Cour d'arbitrage du sport. So the Sports Arbitral Tribunal, which is also based in Switzerland, like WIPO, not in Geneva as far as I remember. I think it's in Neuchâtel. And so they look at all the disciplinary, most of the disciplinary disputes in relation to, in particular, Olympic games, and also some of the disputes relating to commercial issues in the sports space. So now what's going to happen with games and esports? So that's what I'm going to write about in a bit, and so stay tuned for that. Yeah, so this is really what I had to say about the updates on how to make the most of alternative dispute resolution for the creative industries nowadays. Just to let you know, actually today the London Arbitration Week just started today. However, unlike the California Arbitration Week and the Paris Arbitration Week, which were free, one has to pay £450 to attend, which is around 500 euros or $550, which I think is, really sends out the message that the London Arbitration Week is still very, an elite event and field, and also only trusted by the Old Boys Network, which I think is a bit of a shame, because this is not the message that one wants to send out in the world. So shout out to the LIDR, the London Arbitration Week, and maybe they need to think about that to become more democratic and also better promoters of alternative dispute resolution in London. So yeah, I'm just going to check whether we have any questions. Let me have a look at our, okay. So Timothy is asking, so what do I need to do if I have a dispute with one of my counterparties in a commercial agreement? I'm based in the UK and I have a dispute, and how do I ensure that it is resolved through arbitration? Well, first, Timothy, you need to have a look at your agreement, which is underlying this dispute, this commercial dispute, and you need to review it and to ensure that you've got an arbitration clause in this commercial agreement. If you do, that's great, and then you can just file an arbitration claim with the alternative dispute resolution institution, which is in charge of managing the arbitration. As I mentioned before, it is possible that in this arbitration clause set out on your contract, there might be a preemptive step of attempting to resolve the dispute through mediation. That's a possibility. First stage, you try to do a mediation, and if the mediation fails, then you go to arbitration. So just follow the process which is set out in the arbitration clause, if it's been drafted well in your commercial agreement. If there are no arbitration clauses in your commercial agreement, well, there are two options. Either there is a jurisdiction clause which provides for the competence of either the English courts or a court on another country in the EU, as I think you mentioned that it was you mentioned that it was a contract between the UK and the EU. So if that is the case, that's a bit more tricky, because it means clearly that the parties have decided to resolve this any dispute via the courts. So you may approach your counterparty and with whom you have got the dispute and say, okay, would you consider resolving this this dispute by way of arbitration? And if the other counterparty says yes, then you can actually amend the commercial agreement in order to change this clause from a court's competence clause to an arbitration tribunal clause. So I've not seen that very often in practice, but this is something that could be done potentially, and therefore you then need to liaise with your lawyer to draft such an amendment agreement to the main contract to then get an appropriate clause for arbitration. As I mentioned before, this arbitration clause needs to set out the forum. So the physical place where the arbitration will take place, the law under which the arbitration will be governed, and also which ADR institution is going to be competent for the resolution of this dispute via arbitration. And and if there is no jurisdiction clause, then same drill. You need to approach the counterparty and say, would you agree to amend the commercial agreement so that we add an arbitration clause to this agreement so that we're able to resolve our dispute via an appropriate ADR body? If they agree, then you can do this amendment and add it to the to the commercial agreement, and then you can file the arbitration claim with the appropriate ADR body. So that's how you would proceed, Timothy. Okay, so I'm not seeing any other questions. So I guess we're going to wrap up here, and stay tuned for our next article and leadership thoughts on gaming, esports, and dispute resolution. Bye, guys.